At the conclusion of the International Military Tribunal, there were 11 subsequent trials at Nuremberg. The chief prosecutor at the case number 11, the ministry's case, was William Kaming. William Kaming was at the last trial, the ministry's trial, and here are his recollections of Robert Jackson and Nuremberg.
And the legacy, I think, of Mr. Justice Jackson, who was the most towering figure to come out of all the trials, because his words will live in international law and history. But he had a genius for inspiring the best in people as far as their aspirations and vision. And I think the legacy in part is that victors can apply a rule of law. You know, it's been argued by many, not only German nationals, but also a lot of people in this country with hindsight as they sit on their backsides, that it's victor's justice. The fallacy of that is that if Hitler had won, there would be no questions. There would be no justice. There would be no rule of law. No one in Germany has ever challenged, none of the defendants ever challenged the fairness of the trials. But they did not have adequate counsel. Each had at least 2. Weizsäcker, for example, had 4. They had the best minds. They had an open trial with a free press reporting every incident, poring over every document. There were no secret documents. There was no secret trial. This was law at its supreme high. It was the first time that an international trial had been held that was on questions of world interest. And as Mr. Jackson himself said, you know, what we write large today, we will be judged by tomorrow, with the poison chalice. I was born in New York. I lived a great many places, sort of all over. I went to New York University. At that time they had a branch at a place called University Heights, which was outside of the mainstream of the city. And then I went to Harvard Law School and graduated in 1941. And later, coincidentally, when I was at Bell Labs, since they wanted lawyers to have a little more luster, since there were so many PhDs at Bell Labs,
Right.
I took a LLM in labor law at New York University downtown. And I was with Bell Labs for 4 years, and then went over to AT&T as sort of general labor counsel for long lines. At that time did the bargaining for the Bell system, which had 1 million employees, so it was a lot of fun.
My God. Were you destined to be a lawyer? Were you destined? Was that something you
No,
thought?
I wasn't. I had an uncle who was a very famous, in his time, surgeon and brother of my mother, and he was a celebrated doctor. So I thought I sort of was designated that I would be a doctor, and I found very quickly when I went to college, the first 3 months, I broke the record for breakage for a year in the laboratory. finally winding up by putting one of these long thermometers that you opened. They had a wooden casing. You opened it, extracted the thermometer, and somehow I got it through my palm. 1941, when I graduated, I'd been in the Air Force Reserve to some degree, and I had known that war was coming very vividly because every year from 1935 to 1939, I spent 4 months abroad in Europe. And I spoke quite good German, French, a little Dutch, a little Norwegian, and some English. And
what took you to Europe?
My father believed it was just great to travel, and that traveling for a young man was as educational, or more so than formal education alone.
Right.
So I loved it, and my family had been long separated at that time. There was an early divorce in the family.
Right.
And I was in Germany, Austria, Czechoslovakia, long before World War II. And in fact, I was in Scotland in September of 1939. I was walking in John O'Groats Land on a hiking trip. Came out in Inverness to learn that the world was at war. And of course, I was very excited about that. It was no surprise to me because I had seen it coming. I had seen Austria under the Nazis and seen Germany under the Nazis, and had no illusions that they were going to keep going as far as they could. And in fact, I spent 2 glorious weeks in Scotland waiting for a ship, because all of the British ships, the Canard Line and others, had been immediately taken over by the British government on September 1, and we had to wait while small American ships came over to pick up the hordes of Americans. But those days I was more interested in knowing whether I'd survive, but I was quite fascinated. I came back to Harvard, and of course we would receive all the broadcasts from Canada.
Right.
And in June of 1940 was the Battle of Britain. And I was pretty well certain that war would be coming shortly that would involve the United States, since the World War II was then raging while I was in law school. And so when I graduated, I had a number of the usual offers starting level. And one was from the British Ministry of Supply mission. So I was very delighted to take that, because I anticipated I'd only be there about 6 months. Since I went in about September of 41. I had graduated in June of 41. And as a result, I did a lot of work in the legal department, a lot of litigation in the area of Lend-Lease at that time. They were very involved in the Lend-Lease mission. The United
Tell me
States,
explain how that worked. I've heard the term.
well, a deal was set up between, after the losses sustained by Great Britain on the Atlantic were so heavy, submarine losses, they desperately needed additional ships. So we gave them, literally, 50 overage destroyers to serve as escorts for the convoys. And I was just getting train of thought is broken for a moment. The quid pro quo were various bases that were given, and in addition, for example, Bermuda was one of the bases given to us so we could establish a naval base there.
Right, right.
And there were a number of others that were quite important. And Roosevelt was very keen on supporting the British, but there was a very strong anti-war movement, particularly from the extreme right,
Right.
conservatives like Rankin. And so after much negotiation between Churchill and Roosevelt, we made this deal. In addition, we loaned them, after the British had literally used up all their assets in the United States, a number of billions of dollars to purchase our products. And that was on a payback basis, and the actual leasing of the bases was part of that deal. I think we had a 99-year lease. We recently gave up our lease on Bermuda, for example.
Interestingly enough, since I'm involved in the Robert Jackson Center, Robert Jackson was the Attorney General at the time, which rationalized or wrote the opinion, which Franklin Roosevelt relied so that he felt like he didn't have to go to Congress in order to cut the deal.
It was very interesting. I just realized now when you say that, how what goes around comes around. So later, one of my vital, important duties at AT&T was to handle all relations involving electronic surveillance with the Department of Justice and other law enforcement agencies. And I also testified very extensively before Congress on that. And one of the key questions was whether we thought that the Attorney General, acting in the name of the President, could engage in wiretapping without court order under the general powers of the President as Commander-in-Chief and in charge of foreign policies. And the 1968 Act creating the Federal Wiretap Law had a provision that was ambiguous. In essence, they ducked the issue and said the President can act to the degree that he's constitutionally permitted. And so we were quite involved, and I personally, in handling that situation. And one of the first building blocks in our rationale was the agreement between Attorney General Jackson and Franklin Delano Roosevelt, in which Roosevelt, about 1940 or 41, authorized the Attorney General to engage in wiretapping for intelligence gathering purposes. And I just realized it now when you talked. I mean, it just brought it to mind.
Kind of give me the stepping stones to find yourself at Nuremberg, Germany.
Well, when I graduated and was commissioned in the Air Force, I went into the Air Force, and I thought I was going in much earlier, because after Pearl Harbor I anticipated being called up very shortly. And in fact, I had told my employers in the British Ministry of Supply mission when they hired me that I didn't know how long I would stay, but since they were at war, this was a very understandable position to be in. But it turned out I was there for, I wasn't called up until February of, I guess January or February of 1943, which was an incredible time, but they, for some reason, they weren't calling up reserves, they were calling up draftees. but the Army never, and the Air Force never made any sense to me. So when I was commissioned, you had a choice of 4 or 5 different locations that you could request. And if there were any openings, they would assign you to that particular opening. So of course I asked for 5 European openings. And I was a cadet captain, which was a better than average position. That was probably 3rd highest in that little class. So I was one of 5 out of a class of, I guess, about 60 that went to the Far East. Never did figure that out. Except that the Army and the Air Force always, well, it was actually at that time it was the Army Air Force, seemed to send you to a place that you certainly had no experience and to ignore any experience you had. And of course I had so much European experience and spoke several languages and so forth. So during my time in the Air Force, I had as an extra duty a lot of Judge Advocate General work, Prosecutor, which I had loved because it got me all over, particularly India, and it was really lush being able to travel to a city, because we were stationed mostly up in Assam in northeastern butt of India, near the hump. And so then after Japan surrendered, we took a plane back to Hamilton Field in California. And then I was reassigned to the Ferry Command at Wilmington, Delaware. But we got 30 days leave because they really didn't know what to do with us. There was this huge end of the war pouring in of troops. And in fact, when I landed in San Francisco, and of course, this was the first civilization really I had seen. We were stranded for 2 weeks in San Francisco. So I and one of fellow members of the crew tried to get a suite at the Mark Hopkins Hotel. And that was my first time in San Francisco. And we finally got the only available suite. We got a bridal suite. And we spent 2 weeks there before coming across. Well, when I got to Wilmington, I was immediately said, go home for 30 days, rest and recreation, R&R, which was standard for all returning troops at that time. In fact, they didn't know what to do with all the men they had on hand. And while I went home to Florida, and I had been home a very short time, and I received a call from Brigadier, then Colonel Telford Taylor, who was in Washington, D.C., and he had been sent over by Jackson after having been appointed the successor General Counsel to recruit. And there had been some criticism, I understand all this is just hearsay, that at the first trial there hadn't been enough young lawyers who had been in the war serving at Nuremberg. So he came back to recruit, and among others he was interested in getting younger lawyers. And so he asked me to come down for an interview, and I came down the next day, and he laid it out, and we managed to hit it off. So he made an offer. He said, like, to have me assigned, and he asked me what I thought of it, and I said, well, it sounds great. Do I have time to get a toothbrush? But actually,
He knew Europe so well.
it was a few weeks before transportation was arranged by ship. And a couple of others, I think there were about 6 men and a great many war brides, some with children, returning to Europe. So we had a very pleasant trip, as you can imagine.
Did Telford Taylor outline to you what part of the case you might be involved in?
Yes, well, he was very interested in the fact that I had spent a number of years in Europe and was quite conversant with, you might say, both sides of the picture.
Right.
And I had been to I had been to all of Western Europe with the exception of Spain and Portugal. And I had 5 abortive attempts to reach Spain, which is a story in itself. And then I had known a number of the countries in the East, Poland and Czechoslovakia, Russia, Finland. So he was particularly interested in aggressive war counts. We discussed that, and how I would feel working on the Foreign Office matters, and I was fascinated by that. And I particularly was keen on the aggressive war aspects of it. And as it turned out, when I went to Nuremberg, I arrived, I think, and I'm not sure, but about July of 1946. The first trial had started in October. Well, actually, the actual first day was, I think, November 1 of 1945. And the trial was at its height when I arrived, the first trial.
Okay.
And I was assigned to the Political Ministries Division. I was a prosecutor. And Dr. Robert Kempner was the Deputy Chief of Counsel in charge of the Political Ministries Division. At that time, there was no case as such. There were a series of focal points, and it was contemplated that there would be 3 or more major trials than actually transpired. And the reason I mention that, the ministry's case, or the Foreign Office case, has been called case number 11, represented a crunching consolidation of these 3 or so major elements. And it was almost a painful process of selecting the defendants, which fell mainly on the shoulders of Telford Taylor and people like Sprecher and Kempner in making those selections. The reason for that was that, and perhaps I'm getting ahead of the story, there was quite a change in public opinion, in American foreign policy, in historical alliances, and as a consequence, there was a lot of pressure to end the trials. President Truman also was not as gung-ho in his associations with Churchill and even with Stalin. He didn't have the long-term relationships that Roosevelt did.
Right.
Consequently, he faced other problems. He was very supportive, but he had a lot of pressures on him. And I may be getting ahead of the story on this, but as it was, in July of 1946, flashing back, when I arrived, I was assigned to that, and I was assigned to work in the Foreign Office case. And Kempner and I hit it off very well. he was a very interesting person. I can comment on that later if you wish.
Sure.
And he asked me principally what aspects of the case I would like to handle, and I said I was interested in all the aspects, of course, but the war crimes and crimes against humanity, including genocide, were fascinating, but not really as challenging from a legal standpoint, an intellectual standpoint, as aggressive war crimes. And of course, also having spent so many years in Europe, I was quite keen on the exploration of the actions of the Foreign Office and the development of the aggressive war crimes. So I spent most of my career at Nuremberg on aggressive war crimes.
Did you have a chance in July of 1946 and prior to the verdicts in October of 1946 to interview any of the defendants?
Yes, in fact, I regularly attended quite a few of the sessions of the trial, and I had we interviewed a number of the defendants, Von Ribbentrop and Goering, Scorzini, and a number of the other defendants who were involved one way or another, some of the military men, in their role in aggressive war preparation, cases like Case Groom.
Now this would have been, the time you would have had access to interview them would have been after their trial, but before the verdict was rendered? Is that the time period? You walk into the cell, or however, I shouldn't say the cell, but wherever the interrogation room is, and for the first time you're kind of eyeballing Joachim Ribbentrop. You know, what's your reaction? You see this guy, does he look like a...
Well,
what's your impression of him?
I'd had some briefing on him too, and I had studied his background, and I didn't hold him in high regard. So I think this was significant. He was not particularly impressive. There were very few of the defendants who were seemingly as lacking in personality as Von Ribbentrop. I mean, he was not a dynamic figure, and he had a lot of the graces that a diplomat has, and he retained shreds of that. Goering was by far the most dominant personality at the trial when I witnessed it, and he was definitely the focal point. Speer, whom Henry King knew quite well, and later recently wrote the book about him, sort of headed one camp, and Goering headed another camp. And there were divisions within the defendants. Men like Schacht sort of held themselves away from people like Goering. I did interrogate him, with Kempner did, and I was present at the time and observed him, and we talked some, and I asked him a few questions. But the primary interrogation was carried out by Kempner, who had a long personal association with Goering. In fact, I think Goering had ousted him from the key ministry, I think it was of Interior, in Prussia, when the Nazis took over. I was very impressed with Goering's recognition of the fact that he was, one, the leader of this group, the most prominent Nazi still alive, that he would have been the heir to Hitler in Hitler's will until that last abortive attempt to seek peace, and then Hitler wrote him out of the will.
Right.
But he was the successor, and he was a very attractively domineering figure. He was sort of like the lion at bay. He gave no ground, and he recognized that if anyone was to hang, he was most likely.
Yeah.
That was one theme that Goering and all the defendants harped on, and one that the judges really never faced.
Right.
And they had that doctrine that we lawyers called tu quoque,
That's right.
where it was decided that the fact that the Russians had committed, say, acts of aggression, even assuming that arguendo, as lawyers were prone to say, that would not exonerate the Germans, that they were co-aggressors, co-criminals at best. And yet, by the time of our trial, those arguments and the words of Goering and many others of the defendants in the first trial had come to fruition. And the times had changed greatly.
The Chief Prosecutor for the United States of America.
The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility.
I thought Jackson's opening statement, which I had not seen, but of course I had read and practically memorized shortly after I was there, and his entire leadership was outstanding. I think he was the inspirational leader, and I think the courts recognized that he was the court recognized that he was providing the vision and the real purpose of the trials, and to ensure that the rule of law prevailed. Also, as a Supreme Court justice, he carried a lot of personal prestige, and that having been said, there was quite a concern that Goering had far gotten the better of him. And Goering was almost contemptuous of him. And he sort of rattled Jackson to the extent that he had to resort to the court and ask them to direct the witness to, answer without any exposition on his answer.
Right.
And I had tried enough cases, certainly was still very young, but I had tried perhaps, having worked in the Ministry of Mission and then Judge Advocate General, or quite a few prosecutions, particularly in the military. And I too was able to notice the contrast between the presentation by Jackson and the presentation, for example, by the British attorneys.
Maxwell Fye.
Yes.
Yeah.
And they were professional. The British delegation was very experienced very capable. They had a much smaller group of attorneys, as I recall it. And Sir Hartley Shawcross, whom I enjoyed meeting on a number of occasions, really wasn't too active. Sir Maxwell Fyfe really carried the burden, and he was incomparable.
Right.
And there was a great deal of consternation at the end of the first day of the cross-examination of Goering, because Goering seemed to have bested Jackson. And in fact, if I remember correctly, Sir Maxwell Fyfe took over.
Yeah, shortly, I think after the third day,
Yeah.
then he took over.
And sort of bringing the 7th Cavalry to the rescue.
That's right. That's right. And I think that's the impression even.
But I think Jackson labored under certain handicaps. Having been Attorney General and having been on the Supreme Court, I'm sure his skills in the courtroom were somewhat rusty. And also, particularly as Supreme Court Justice, you wear an imperial mantle, and you have attorneys and witnesses very responsive to your every wish and very courteous and never assailing your person.
Sure.
And here he was confronted with someone who, well, all of them, who he did not recognize were not ordinary defendants. These were men of great political stature and great political skills and acumen. And many of them were military men, and he was neither of these. And on the other hand, someone like Maxwell Fyfe was quite accustomed to trial work. And he was supported by very able counsel who were also very experienced.
Hermann Wilhelm Goering, on the counts of the indictment on which you have been convicted, the tribunal sentences you to death by hanging. Joachim Von Ribbentrop, death by hanging. Fritz Saukel, death by hanging. Julius Streicher, death by hanging. Wilhelm Frick, death by hanging. Hans Frank, death by hanging. Alfred Rosenberg, death by hanging. Wilhelm Keitel, death by hanging. Ernst Kaltenbrunner, death by hanging.
Also sentenced to death were Jodl, Seyss Inquart, and Martin Bormann, who was tried in absentia. Hess, Funk, and Raeder got life prison terms. Speer, von Schirach, von Neurath, and Dönitz got long.
What was the buzz as the verdicts came down, and there were actually 3 acquittals? Did in your prosecutor's pool, was there a reaction to that?
No, there was no surprise. The case against Fritzie was very weak. The case against von Papen was quite weak because at most he was involved in the aggression against Austria and perhaps a little of Czechoslovakia, and otherwise any advocacy for the Third Reich done as ambassador to Turkey was after war really got underway, and was minimal. And Schacht, there was no question about him. The only reason he was inserted was because of his position and name in international circles. There was some question as to the penalties, particularly among the military men. Goering although he was the Reichsmarshal, was essentially a political figure too. But Jodl, Raeder, Dönitz, Keitel,
Okay.
there were a lot of concern that perhaps, particularly Jodl's position, that they might have given him life imprisonment instead. And there was also the danger, particularly in their cases, of sort of victor's justice. The general reaction in Nuremberg among the Germans that we were contacting, the general population, was sort of mixed. I think many of them were more concerned with just staying alive and
Right.
where their next meal and their next cigarette was coming from rather than the trial. I think the Russian behavior in East Germany and Berlin in particular, and the general hatred for the Russians, flavored the attitude of people, at least in Nuremberg, and perhaps throughout the western zones of Germany, against the trials. And there were strong undercurrents.
Did you have any chance to actually meet him, Jackson?
I met him a couple of times, but very briefly, and
Yeah.
It was more or less just socially, so
Right.
I really didn't have an opportunity. We were, as the trial ended, we were swamped with work, interviews, documents were pouring in and discovered, attempting to get as much as we could out of the defendants and their witnesses, many of whom were at the courthouse.
I can envision that there was sort of a mad dash, knowing that some of these guys aren't going to be alive in a.
Exactly, and interviews with Ribbentrop were not very profitable to us because he had very little to contribute, and he was not too outgoing. And a lot of other members of the German Foreign Office were being interviewed at the same time, and we were sort of trying to play one against the other. But there was the closure of the first trial, and there was a lot of uncertainty. What happens next?